Hi everyone, welcome to today's webinar, Prepare to Repair 2025 Right to Repair Requirements in the EU, US and beyond. So a little bit of orientation about the webinar platform before I introduce our speakers for today. The webinar slides are available to the left side of your screen, along with a few helpful links if you would like to explore and learn more about compliance and risks and how we can simplify and accelerate your compliance processes. We want this webinar to be as engaging as possible, so please send us any questions you may have, and we'll aim to address them at the end of the webinar during the Q&A session. And if you would like to submit a question for this Q&A session, use the Ask a Question widget on the left side of your screen. And we will also follow up with you directly for any questions that we don't get to during that time. At any time, if you're interested in having a member of our team follow up with you, please don't hesitate to use the Start a Conversation button at the bottom of your screen. And last but not least, the webinar recording will be sent to you along with the slides within 24 hours. My name is Orla Morris, and I'm the Content Marketing Manager here at Compliance and Risks. We're joined by the wonderful Michelle Walsh, Kelly Bugera, Samantha Aguiano. Michelle is an Irish qualified lawyer currently living in Belgium with over 16 years experience in global environmental and product regulation. Her role involves tracking and monitoring key regulatory trends and legislations. Her insights and analyses help clients meet their essential legal requirements relevant to their business needs. Michelle has a particular interest in sustainability and circular economy, and her specialty areas include the circular economy, waste, electrical and electronic equipment, the transboundary movement of hazardous waste, ESG, sustainable resource use, eco-design and energy efficiency. Thank you so much for joining us today, Michelle.
Hi everyone, really looking forward to today's session. Thank you.
And we're also joined by Kelly Bugera. As part of her role at Compliance and Risks, Kelly specialises in researching and monitoring legislative activity on the US state and federal levels, as well as tracking international developments related to topics of customer concern. With over 30 years of experience in the field of product compliance, she is involved in an array of special customer consulting and assessment projects that cover international standards and regulatory activity for a variety of products and topics. Her areas of special focus include circular economy, ESG, anti-bribery and anti-corruption, chemicals, product safety, consumer electronics, and drinking water. Thanks for joining us, Kelly.
Thank you, Orla, and thank you everyone for joining the webinar today.
And last but not least, we're also joined by Samantha Aguiano, a Mexican qualified lawyer currently living in the US with over 7 years of experience in legal research, negotiation, and regulatory compliance. Samantha is currently part of the Global Regulatory Compliance team at Compliance and Risks, where she conducts regulatory analysis at several US state levels, as well as internationally. Prior to Compliance and Risks, Samantha has years of experience developing risk mitigation strategies and implementing compliance policies. Thanks, Samantha, for joining us.
Hello, everyone. I'm really excited to be here.
So before we kick off the webinar, I would like to provide a brief background about Compliance and Risks for those who are joining this series for the first time. At Compliance and Risks, our mission is to help ensure global companies have the tools and information to build safe, sustainable products in a world full of change. We are the trusted partner. We are the trusted product compliance technology partner for the world's leading brands and have spent 2 decades honing the digital tools, expertise, and content you need to stay ahead of the dynamic regulatory landscape and prove your product's compliance, protecting your brands and helping drive your growth. At Compliance and Risks, we have the world's most comprehensive regulatory database with over 100,000 regulations historically available in C2P. With a global regulatory coverage and expertise across over 20 industries, we understand that regulatory compliance definitely doesn't sleep. And our regulatory expert team is truly global, with 28 languages collectively spoken across the team, all fortified by our 30 knowledge partners. C2P is our enterprise software, the key to unlocking market access as new products can be designed and built with full confidence you've met all compliance obligations. And this includes early warning alerts, impact probability, productivity workflow tools, and so much more. And with that, I am delighted to hand it over to you, Michelle.
Thank you so much, Orla. Okay, so hi everyone. So today I'm going to take a deep dive into the EU requirements, what's happening across the EU and all the intricacies of EU legislation on the right to repair before I pass on to my colleagues Kelly and Samantha in the US. Okay, so here we go. In the EU, you have the Right to Repair Directive, and this is the main directive around right to repair. It's in force since July 2024, but the member states have another 2 years till July 2026, actually 1 year now, to transpose it into their national legislation. There are three major parts of this directive which you need to know about. The first one, which is actually quite easy to miss in the directive, is that it amends the Sale of Goods Directive. And what this amendment does, it allows the consumer, if they choose repair over replacement, it gives them an additional 12 months extension of the legal guarantee. So this happens within your guarantee period, which is 2 years in the EU. If the consumer chooses repair, they get an additional 12 months legal guarantee. So this is very significant. It applies to all consumer goods under the Sale of Goods Directive that are bought after the 31st July 2026. Additionally, the seller must inform the consumer of their right to choose repair over replacement. And if they do so, that they get this extension of the legal guarantee. If they choose replacement, if they say, no, I want a new product, they don't get any extension on the legal guarantee. So there you can see how this is really prioritizing repair across the EU. Next to this, there are additional requirements for certain products. And this is what caused a bit of confusion, in that these additional requirements only apply to certain products that are covered by eco-design regulations and the batteries regulation, which are listed in Annex 2 to the directive. So for these specific products that are covered by these eco-design regulations, the batteries regulation, there's another set of requirements for the manufacturer. So what it requires is that the manufacturer, if they're asked to repair a product, even outside the legal guarantee, they must offer repair. And they must offer the repair at a reasonable price and within a reasonable time. So it's no good if you need your washing machine to be repaired and it's going to take you 3 months at a crazy price. This is gone now. There's a legal requirement for manufacturers to provide a reasonable price, reasonable time when they're actually offering repair. When the product's being repaired, they can offer a replacement product free of charge. And if they can't repair the product because it's completely impossible, they should offer a refurbished product first rather than a new product. Additionally to this, the manufacturer needs to provide a list of prices for typical repairs on their websites. Spare parts must be offered at a reasonable price, and they can't use any practices that hinder repair. So the examples they give in the directive are things like contractual clauses, hardware or software techniques that impede repair. Now, there is a little caveat to that. It says, unless this is justified. And in the directive, it says an example would be for the protection of IP. Now, this has caused controversy across the EU. Some people regard this as a significant loophole in the legislation. So it's going to be really interesting to see how the EU Commission tackle this. Also, you cannot refuse repair for the sole reason that another repairer or repair shop has repaired it, which was a practice that some manufacturers were doing. The third part to this directive, which is important, is that it requires the EU Commission to create an online platform for repair. This is basically a single platform where a consumer can log in free of charge, and it will link then to the member states' national online platforms for repair. So essentially, consumers will be able to find a repairer where they live locally for the products that they need. It's voluntary registration for repairers, but it's a really good marketing tool for them. So it will be in their interest to be on this website. And we're expecting this to be fully operational by 2028. So that's the Right to Repair Directive in a nutshell. But why it's complex and where you you need to look at it in the broader context of a number of other key EU laws. And this interconnection and this interplay between the laws is what's making this a little bit tricky, I suppose, for manufacturers to deal with. The first regulation, which is important to look at, is the Ecodesign for Sustainable Products Regulation. This is the ESPR regulation. So I mentioned that the Right to Repair Directive applies to certain eco-design regulations that are listed in Annex 2. This is these additional requirements for a repair outside the legal guarantee. But when you're looking at where can you find these eco-design regulations, we have a new framework in the EU. This framework basically requires that sustainable products will be the norm across the EU. And a key element to designing sustainable products is repairability. So you need to be aware of what regulations are coming down the line that will have repairability requirements included in them. And to understand that, the EU Commission is going to publish its first working plan. It's the deadline for this is April 2025, actually in 10 days. So this is the deadline in the regulation, and it's going to set out the priority products which the Commission is looking at for future eco-design regulations over the next few years. It has indicated there is a short list in the regulation that it may look at things like iron and steel and textiles and furniture, for example. Also, energy-related products that are new or need to be revised as well may be included. There are a number of eco-design preparatory studies going on at the moment looking at whether eco-design requirements should be set for different product groups, and commercial dishwashers is one that's being studied, as well as commercial laundry, which is your washing machines as well. Interestingly, recital 15 of the ESPR regulation actually refers to the importance of having horizontal requirements for repair and durability. And this would mean horizontal regulation would actually cover a number of product groups together. So this is called out in this framework. Another thing to look at when you're looking at eco-design, there's actually a deadline under the ESPR regulation which allows legacy products. So these are products that are already regulated on the previous eco-design directive. The Commission can still enact regulations for those up to the 31st of December 2026. So for legacy products, they are looking at some of them to see will they revise them before they fall under the ESPR framework. If they do so, they still are under the previous eco-design directive framework. The difference is if we go past the 31st of December 2026 and these products fall under the ESPR, they have a lot more requirements than they would have had under the existing eco-design directive, such as carbon footprint requirements, digital product passport requirements. So this deadline is very important. And the EU Commission is looking at certain products at the moment to see whether they will have an eco-design regulation for them. One important one is the eco-design regulation for servers and data storage products. There is a draft circulating this at the moment. It was discussed at the Eco-Design and Energy Labelling Consultation Forum, which was on the 10th of March, which I had the pleasure of attending in Brussels. Interestingly, we're seeing a few newer requirements around repair. We're used to seeing that spare parts need to be available for a certain period of time or delivered within a certain number of days. But it's also looking for potentially asking for a list of pre-tax prices in euros, including prices for fasteners or tools to be on the manufacturer's website. And this ties into more the thinking under the Right to Repair directive with the online platform. It's having these information on prices available. Another thing which is interesting is that it does discuss a ban on parts pairing. Under this proposal, it has requirements around replacement of serialized parts. So these are parts that need unique codes, because of these unique codes, they have to be paired to specific devices. And you can't replace them unless you have the correct software codes. So what this proposal is asking is that the professional repairers will be provided with the correct software tools to ensure that they'll have these parts will have full functionality in the device that they're installed in. So this will open up the repair market for these parts. So these are just some of the newer requirements we're seeing in relation to repair. So that's eco-design. Batteries is another one. Batteries is actually the batteries regulation is referred to under the Right to Repair Directive. Specifically, it refers to light means of transport batteries, which are batteries that are used in e-bikes and e-scooters. So what the batteries regulation says is that these batteries must be removable and replaceable by an independent professional repairer. And these spare parts need to be available for 5 years after placing the unit model on the market. What does that mean? Because light means of transport batteries are referred to in the Right to Repair Directive, if you're a manufacturer of an e-bike or an e-scooter, you must offer repair of these LMT batteries if you're asked by a consumer on reasonable terms at a reasonable price for these 5 years that those spare parts need to be available. If you want further information on removability or replaceability of LMT batteries, the EU Commission published a guideline on the 10th of January, which is really useful for those interested specifically in batteries. Another one which you wouldn't necessarily associate with repair is the Greenwashing Directive. This is how you advertise your product. What can you say about your product? So it prohibits generic green claims or environmental claims that are not based on recognized environmental performance. So this directive actually amends 2 other directives. It's like a spider web of requirements that are all connected. So the first is the Unfair Commercial Practices Directive. And what it says in terms of repair is that you cannot present your good as allowing repair if it does not. Secondly, you can't be falsely claimed if you use the product in a certain way that it'll last a certain time. Equally, it also amends the Consumer Rights Directive. And what it says there is that before the consumer is bound by the contract, you must include a repairability score of the product, if there's one available, or information about cost of spare parts, how to order them, repair and maintenance information, and any repair restrictions as well, which is quite important. So that's just an interplay of some of the major EU regulations that we're seeing that have repair requirements and how they need to, when you're looking at the right to repair, I suppose, movement, you need to kind of look at these interconnected regulations as a whole. But other than that, we are seeing repair labels popping up around the EU as well. In France, there is a repairability index. This is around since 2021. So France really has been one of the leaders with circular economy. It has a very, very strong circular economy law in place, which is from 2020. Then it required basically a repairability index to be displayed in the shops near the product or on the product packaging. And this essentially is a tool to inform the consumer how easy it is to repair the product. So in very layman terms, if you see red, it's bad. If you see green, it's good. A certain number of products are required to have a repairability index since 2021. They increased the list in 2022. And what you have to do is look at five different criteria. So it's documentation, disassembly, availability of spare parts, price of spare parts, and specific product aspects. And you calculate the score of the product in terms of repairability. And this must be displayed near the product in the shop. It moved forward then since the 7th of January this year. For televisions and household washing machines, you have to also include more criteria when you're looking at this repair index. So it's moved to what's called this sustainability or durability index. So in addition to the criteria you have for repairability, you also need to look at resistant to stress, under wear, maintenance and upkeep criteria, as well as guarantee and quality approach. So again, France really moving ahead with these repair type labels. Belgium is now looking at the French example and has its own repairability index, which is coming into force on the 2nd of May. So you're going to see this in Belgium. Interestingly, it has some different products in compared to France. We have got e-scooters and e-bikes as well. And you must display this repairability index free of charge basically when these products are being sold. And it must appear in one of the languages, the official languages in Belgium, so in French, in Flemish, or in German. But it's not just in the member state level. We also have a new energy efficiency label for smartphones and tablets, which includes a repairability index. So this is your normal energy efficiency label, which we're kind of very familiar with in the EU. But if you kind of see on down here, this little icon, it looks like the phone is being dropped and smashed. That's actually your repairability index. And this is going to appear from June of this year. And what do you need to do to calculate whether it's an A to E scale? You need to look at disassembly depth, fastener types, tools, how easy the tools are available to take apart the product, availability of spare parts, and the duration of software updates. And using this calculation, then you have an index A to E on how easy this product will be to repair. This has come under a little bit of criticism in that the French criteria has included the price of spare parts, whereas in the European model, it's just the availability of spare parts and not the pricing. So that's one of the things that we have seen is a bit of criticism around that. Also, it refers to, it's harmonized the standard EN 45554 as basically the standard to be used for assessing things like disassembly, fasteners, and the skill level for basically the disassembly. This particular standard, it's the first time we've seen it harmonized under one of the EU regulations, but it is also referred to in the draft regulation for servers and data storage products. So I do think the trend is this will be actually a harmonized standard for eco-design requirements going forward in terms of disassembly and tools, specifically and the skill level needed to take apart the product. Great, so that's just a deep dive into the EU. I'm going to pass you on to my to my colleague Kelly, who will take you through some of the US requirements. Thanks.
Thanks, Michelle, for the information on the EU. So as Michelle said, we're moving on to the US. And currently, there is no federal level right to repair requirements in the US. However, there are state level requirements that have been enacted. Today, we'll talk about 5 of these state level requirements, mostly dealing with consumer electronics, digital electronics, appliances. There are, however, additional state requirements that have been enacted for agricultural products, automotive related products, but we'll touch on these 5 today. So starting out with New York's Digital Fair Repair Act, this has been in force since December 28th, 2023, stating that an original equipment manufacturer, so the OEM, must make available to independent repair providers as well as consumers, so the product owners, necessary documentation, parts, and tools for the proper diagnosis, maintenance, or repair of the digital goods covered under this act. And this has to be done on fair and reasonable terms. In New York, the definition of digital electronic equipment is any hardware product dependent on digital electronics embedded in or attached to the product and sold after July 1st of 2023. It's interesting to note, though, in New York, there's a specific exclusion for products sold under business to government or business to business contracts. So basically products not sold at retail to consumers. So you'll see as we go through these state requirements, they have some similar components to them, similar terminology as far as referring to OEMs and referring to diagnosis, maintenance, and repair of electronic goods. However, there's distinct differences, which is why we need to treat each state separately and examine each state's law separately. So now we'll move on to California and their Right to Repair Act, which has been in force a little bit over a year, since January of last year. So they state that manufacturers who sell electronics and appliances, so unlike New York, California also applies to appliances being sold to retailers or others in the state in order to provide the product owner, service and repair facilities, or service dealers with, again, the necessary documentation, parts, and tools for diagnosis, maintenance, and repair. And unlike the other states, California does something different in stating that the wholesale value of the product helps determine what requirements you need to comply with, if you need to comply with anything at all. So if you have an electronic or an appliance, but the wholesale value is less than $50 US, you don't have to do anything. If your product's value is $50 to $99.99 wholesale for a minimum of 3 years after the last date of manufacture, you need to comply with the requirements. If your product is worth a little bit more, $100 US or more wholesale, you would need to comply with these requirements for a minimum of 7 years after the last date of manufacture. So again, this is different than how the other states have it laid out. And again, unlike New York, in California, business-to-business transactions are included. So whether you're selling your products to schools, businesses, governments, or other means outside of retail sale, you need to comply with the requirements in California. And as I mentioned, the California requirements do include appliances. So that's refrigerators, freezers, microwaves, for personal, family, or household use, or in use in motor vehicles. So again, you can see there's some similarities between New York and California, but some distinct differences. So you need to make sure you're up to date on what the requirements are in each state. Now, moving on to Minnesota, they're much more similar to our first law that we discussed in New York. So they have their Digital Fair Repair Act, which has been in force since July 1st of 2024, stating that original equipment manufacturers are to make available to, again, independent repair providers or consumers documentation, parts, and tools for the diagnosis, maintenance, and repair of digital electronic equipment, which in Minnesota they're defining as a hardware product that's dependent, in whole or in part, on digital electronics that have been embedded in or attached to a product in order for the product to function. Interestingly, though, the distinction between Minnesota, or one of the distinctions between Minnesota and New York, is the definition of an OEM. So in Minnesota, they specifically define an OEM as an individual or business selling or leasing to any other individual or business, again, new electronic products manufactured by or on behalf of the OEM. So by this definition, we know it includes business-to-business transactions, which are specifically excluded in New York. So again, a distinction between the different states. So in Minnesota, the necessary parts, tools, and documentation shall be made available within 60 days after the first sale in Minnesota. And this importantly includes updates in software, as Michelle was mentioning, since those are crucial components to right to repair for digital products. Moving on to Oregon and their right to repair law for consumer electronic equipment. This just went into force this year, so January 1st of 2025, stating that the OEM is to make available to the owner, meaning the product owner or the consumer, or an independent repair provider, any documentation, tool, part, or any other device or implement that OEM would make available to their authorized service provider. So it's a little bit more expansive, the language, but again, for use in diagnosing, maintaining, repairing, or updating the consumer electronic product, again, stressing the importance of being able to update the product as a crucial aspect of repairability. So Oregon is the first U.S. state to ban parts pairing, which Michelle touched on what parts pairing is. So that's, again, using software barriers or locks that are used to prevent a consumer or an independent repair provider from replacing parts that are not, quote unquote, paired or specifically authorized by the manufacturer of the device. So the prohibition on parts pairing is intended to encourage consumers as well as independent repair providers to harvest spare parts from defunct devices for use in the repair of their current devices. And again, this is a crucial aspect of repairability and making sure that consumers and repair providers have the ability to extend the lifespan of the goods. And the final state we'll talk about as far as enacted legislation is Colorado with their right to repair law for digital electronic equipment. Now, this is House Bill 1121 that was recently enacted. It will go into force next January 2026. So they do have a current law on the books as far as right to repair of agricultural equipment and powered electric wheelchairs in Colorado. So what House Bill 1121 has done is it has expanded the scope of right to repair in Colorado. So it now includes digital electronic equipment, which again is defined as hardware products that depend on digital electronics that have been embedded in or attached to the product so that the product can function as intended. So building on what Oregon has done, Colorado has also banned as part of their legislation parts pairing. So they're banning the manufacturers from using parts pairing to prevent an independent repair provider or a product owner from installing a replacement part, or parts pairing would reduce the functionality or performance of the digital electronic equipment, or it could cause the digital electronic equipment to display misleading alerts or warnings about the unidentified parts. So again, as an important aspect of promoting a circular economy and promoting repairability, parts pairing will also be banned in Colorado for digital electronic equipment as of January 2026. So now Samantha will discuss some of the proposed requirements for right to repair for U.S. states and federal.
Thank you, Kelly. So now we wanted to discuss where the U.S. legislation is heading in 2025. And the key topics, these most notable areas that we have seen is over electronic wheelchairs, electronics and appliances, automotive parts. These are some examples of some bills that have been proposed recently. And we noticed that this growing trend shows a clear shift toward viewing parts as a sustainable long-term solution, seeking to eliminate this throwaway culture. And the goal is not only to reduce waste, but also to protect the consumer by ensuring the repair access for essential products they rely on daily. A clear example of this could be the electronic wheelchairs bills that have been proposed recently. We see that they seek to ensure that users can easily access repairs without relying exclusively on the manufacturer. So this approach shows that the regulation goes beyond technological, but also it addresses this access of equity and personal autonomy. And what do we see on the US federal level? So at the US federal level, there has been a proposal, a House Bill 1566. It was proposed in February. And the purpose is to ensure consumers have access to data relating to their motor vehicles. So why is this? Because nowadays the car manufacturers have exclusive control over the vehicle data, especially to that one that is transmitted via internet. So this is limiting independent garage and owners to diagnose and repair cars because they don't have full access to this information. So this bill seeks to require manufacturers to provide owners of their designees with access to vehicle-generated data and share essential repair tools and information with independent repairers and part suppliers. So also it is important to highlight that this bill was proposed before on 2023. It was similar to this one that we have proposed now. But the problem is that it did not advance. And what was happening is that it was criticized for requiring these vehicle manufacturers to provide vehicle-generated data, but it was without any conditions. So people were really worried about that it could pose privacy, data security, and vehicle safety risks. So this new bill that we have proposed, this 2025, is seeking to balance this access to information while protecting the privacy and security of the owner data. The next one. So now moving to the state level, several states have introduced these new right to repair bills in 2025. Some examples that we can see are the Washington State proposed a Senate bill, 5423. It was proposed on January, and the scope is electronic and electrical equipment. So that is like computer, mobile cells, spare parts. And as of January 1st, 2026, an original manufacturer would need to make available to independent repair providers part tools, documentations for diagnosis, and repair of covered goods. So here we can see a clear example of what I was mentioning before. The bill seeks to, one, empower the consumer, so that they can decide how and where to repair, and also reduce this e-waste. The Texas House Bill is another example. This one is for electronic and electronic equipment, and they discuss about, it's kind of similar like the Washington one, because it seeks to enforce manufacturers to provide parts, tools, and manuals to consumers and independent workshops. But there's something really interesting to highlight, is that the bill includes a protection for manufacturers and authorized repair providers from liability of a third party. So if a third party that is not an authorized repair provider, if they commit like an injury, they would not be liable for this. And so basically it expands the access, but also limits the manufacturer responsibility for others to do with that access. So if you have that access, you are responsible for that, and it's limiting the responsibility of the manufacturer. And also another example is the House Bill 3682 from Texas. And this links the obligation to the existence of express warranties of products. That is, manufacturers would be required to provide these remedies only if the product has an express warranty. So also it's important to highlight that our developed approval rating system by C2P has determined that both are really likely to be approved. So we have the first one, for example, 71% approval for the Washington one. And we have for Texas, both of them have a probability of being approved at 69%. And finally, it is interesting also to discuss that some states are proposing amendments to these existing right to repair laws. As Kelly said, there's this Oregon Senate Bill 1596. It has been proposed to be amended by the Senate Bill 550. It was proposed in January, and the purpose is to expand the list of covered equipment, and to introduce electric wheelchairs and complex rehabilitation technology. And also we have a proposed amendment for New York. The Senate Bill 4104 is proposed to be amended by Senate Bill 4655. So they are seeking to update the definition of the OEM that Kelly was mentioning. They also seek to backdate the compliance date from July 2023 to July 2021, and remove some product exclusions, such as home appliances, to broaden this coverage. And these amendments show how states are not only adding new laws, but also redefining the current ones to close loopholes and make repair rights more accessible to consumers. So now I pass the mic to Kelly again.
Thanks, Samantha, for that information. So now I'll just touch upon a bit what's going on in Canada at the federal level and then in the province of Quebec. So in Canada, there are federal right to repair requirements. However, it's not as though Canada has a law called Federal Right to Repair. So what they have done is something interesting. They've recently enacted two laws amending their Copyright Act. So these are Bill C-244 and Bill C-294. They were both passed and immediately went into force in November of 2024. So what they are doing is they're modernizing the copyright policy with regard to digital technologies that had previously blocked repairability. So people were using the idea of intellectual property, if they had some sort of proprietary information, in order to avoid having to give information out so that owners or repair shops could repair digital products. But that is no longer allowed. So under Bill C-244, this now allows the circumvention of a TPM. So that's a technological protection measure. If the action, so if this circumvention is solely for the diagnosis, maintenance, or repair of certain products. In addition, there's Bill C-294, which now allows the circumvention of a TPM in order to make a computer program or a device in which it is embedded interoperable with another computer program, device, or component. So again, these are some more key provisions now in place to enhance repairability in Canada at the federal level. And then at the provincial level, Quebec has their right to repair requirements. So they have an existing Consumer Protection Act, which was recently amended by Bill 29, which has been in force since October 5th of 2023. And this states that there is a ban on the manufacture of goods with planned obsolescence. So again, you cannot intentionally design a product with a limited lifespan, because the goal of these right to repair and circular economy initiatives is to increase the lifespan of these products so they don't just end up in a landfill after a year or two. Also, as part of Bill 29, there is a warranty of availability of replacement parts and repair services for a reasonable time and at a reasonable price for covered products. That's in effect from October 5th of this year. In addition, there's a warranty of good working order. So upon delivery of goods, the consumer has a legal right to expect durability of their goods, such as refrigerators, freezers, dishwashers, washing machines, TVs, etc. That's in effect from October 5th of 2026. So during the warranty period, the responsible parties, such as the retailer or manufacturer, are required to cover the cost of repair. This includes any shipping and handling or any associated costs. So the retailer or manufacturer, the responsible party, can perform the repair themselves, or they may pay another party to do the repair. Either way, they're also required to display this warranty period information near the advertised sale price. And just interestingly, just in January of this year, there are already some amendments proposed to Bill 29. They're basically proposed almost to just provide some better definitions, clarity as far as how to comply with these requirements. So those amendments were just proposed in January with a comment period that extended through March. So we're waiting to see what happens with those amendments. But that's what's happening in Canada. And now I will pass it back to Michelle, and she will discuss some countries in the rest of the world. Thanks, Michelle.
Thanks, Kelly. Yeah, we're just going to have a quick look at some other countries. So Brazil has a proposal, a right to repair law, which is going to amend its consumer protection law. This proposal is very much based around the right to repair EU directive. So there's a lot of similarity. They have looked at the EU example and it is very much aligned to it. So it includes a proposed ban on planned obsolescence of consumer products. It requires suppliers to provide access to tools, spare parts, and instructions. Consumers should have access to at least one digital platform which has repair information, and you cannot refuse repair solely on the fact it was performed by an independent repair shop, which was mentioned earlier for the EU Right to Repair Directive. Interestingly, though, it does include penalties, which is something kind of missing in some of the other laws. Penalties in the proposal is that they could range from 10,000 real to 50 million real. And 50 million real is equivalent to 7.5 million euros. So quite significant. And so it'll be interesting if this amendment goes through. Another country which has proposed a right to repair law is in New Zealand. And what this one is quite interesting. It's more aligned to the US model, I would think. It requires manufacturers to provide information, spare parts, and the tools necessary to diagnose, maintain, or repair the goods. So that kind of similar wording, which Kelly referred to in some of the enacted US laws. But outrageously, in my opinion, at the moment, there is Section 42 of this law, which allows basically once the consumer is notified at the time the product is supplied that there are no repair facilities available, then there's no obligation that repair should be made available to them. So this proposal is proposing to delete that section completely, because that section has been used as a block to repair in New Zealand. So that'll remove this out of jail card pretty much, and empower consumers to request that suppliers repair the goods basically when they need to. So interesting proposal in New Zealand as well. Okay, and just some trends just that we've been noticing and some takeaways. So we looked at the EU Right to Repair Directive. I suppose the product list in Annex 2, the Commission may expand this list to require more products to be repaired outside the legal guarantee. I did hear before Christmas they were working on an amendment, but which would include products that have existing eco-design regulations that have repairability requirements, in such as cookers, for example. So we'll see if we see actually a proposal on that. Legal guarantee, I suppose the importance of it cannot act as a barrier to repair anymore. And I suppose what it's doing, it's making manufacturers really looking at, okay, well, the cost to repair is something that they're going to have to do. Then it goes back to the circular economy model of requiring better design, so they're not going to be hit with this repair cost if they design better products. The eco-design framework, the ESPR, the delegated acts under this are going to have repairability requirements in them. Recital 15 has mentioned we could see a horizontal regulation for repair, but there also will be specific eco-design regulations on this as well. And just, I suppose, for the EU in particular, it's, as I mentioned, it's important to look at the interconnection with a number of the regulations together when you're looking at repair. The US, at the moment, we don't have any federal legislation. Samantha mentioned that there is a proposal for the automotive sector, but it's really the state level where a lot of the action is happening. So it's really important for manufacturers to track the state level in the US. Canada, as Kelly went through, we have some federal law around which they interestingly amended their copyright law to bring in right to repair basically obligations, but it's really the provinces that are enacting the strongest laws. So we have Quebec, I think Ontario as well has another law as well. So it's really provincial level is where to watch. And again, as the trend is circular economy, it's the trend at the moment where everything is going. So right to repair laws will appear in other jurisdictions, and we just gave the examples of New Zealand and Brazil as just one of many, few of many. Okay, so thank you. I'm going to pass you back to, I think, Orla. Thank you, everyone.
Brilliant. Thank you all so much for such amazing insight. That was fantastic. And I see a lot of questions have been coming in, and we'll start to answer as many as we can during the Q&A part of the session. But before that, I would just like to introduce you to our product compliance solution, a smarter way to manage your product compliance. So C2P, our product compliance solution, helps with 4 key components of your product compliance journey. The first one is identifying relevant regulations for your products. We have consistently heard this to be the biggest complexity in this journey, and we're here to solve it for you. The second challenge is communicating compliance requirements to stakeholders so you can efficiently collaborate and make progress in implementing the changes needed to be compliant with these applicable regulations. Following up on that, we help with staying on top of relevant upcoming and proposed regulatory changes. So we have extremely positive feedback on proposed regulations from our customers, since they're able to proactively instead of reactively progress their compliance strategy. And we also help solve for managing compliance evidence documentation, with features such as evidence expiry alerts, so you always have control over your compliance status. In C2P, you can get access to regulatory content covering nearly 40 content areas listed on this slide, which includes regulations, standards, and product requirements that enable you to gain and maintain market access for all of your products globally. You can have peace of mind that global regulations are monitored by our team of subject matter experts for any changes, so you are alerted way ahead of time to keep you on top of proposed changes before they even happen. And overall, our customers testify that with C2P, they are empowered to be proactive about how they achieve, maintain, and expand their market access globally. And our product compliance solution also helps manage all of your compliance in one place, so conveniently, and effectively replacing the multiple sources of information, including webinars, memberships, Google Sheets, Excels, and folders with our one-stop centralized solution. And moving on to industry coverage, our solution is extremely comprehensive and customized for your specific needs with live linked data to keep you in control of your compliance obligations. Each industry deals with specific regulatory challenges, and we have 10 different industries that C2P caters for listed on this slide. Our expert team is, as I mentioned, truly global and the backbone of our solution. They are the superheroes who monitor and maintain the critical regulatory content in C2P with daily updates to ensure you're on top of any changes. And all of our 40+ experts on the team are accessible to our customers at the click of a button in C2P. Where they help address questions on laws and regulations, including purpose, applicability, requirements, highlights, and so much more. And with that, I again would like to thank you for your attention. And we now have the floor open for the Q&A session. Again, if we've had a huge amount of questions coming, but if there's any more you'd like us to answer, please do use the Ask a Question widget to the left side of your screen. So I'm just going to take a look through some now. The first question is, the right to repair movement appears to be mainly from developed countries. Are non-developed countries also looking at this?
Hi, I can take that one. Okay, so there's different kind of, I suppose, it's different culture models if you think about it. So it's not that non-developed countries aren't looking at it. I think there's a different culture. If you think about in Asia, there are repair shops on every corner. So repair is something that's very much embedded in the culture there, and that people repair their products all the time rather than buying new products. The problem in the EU is that when we crack a tiny crack on your smartphone, you go online, you buy a new one straight away. This culture of replacement, this replacement kind of culture is something that the EU Commission is trying to stop. So I think, so that's the one thing to kind of understand it in a kind of a broad context. The trend that we're seeing in kind of non-developed countries is more looking at things like banning planned obsolescence. So I mentioned this in the Brazilian bill. There's another one in Colombia that was reintroduced in September, and that's looking at planned obsolescence. And then you also see things like information campaigns in other countries. Like, for example, in India, there's a right to repair portal where you can go online and you can get information about repair for different products, and manufacturers can sign up to these type of portals as well. So I think it's a lot of the legislation is coming from more developed countries, but this is because our culture, it has been very much, a tiny crack, throw it away. So it's trying to break this trend. Thanks.
Brilliant. Thanks, Michelle. And do you think the approval of the federal bill is likely, and how would it impact the states?
I can take that one for the U.S. So at this point, the U.S. federally, the Congress happens to be, both houses are controlled by the Republican Party, as is the presidency. So there's not really an appetite for more regulations on businesses or more requirements that businesses will have to follow. So it's highly unlikely that any sort of right to repair initiative will pass this congressional session. Now, this congressional session, which goes for 2 years, just started in this past January. It's interesting though, in the past congressional session, the 118th Congress that ended in January, there was digital right to repair proposed. We had 2 bills, one in the House, one in the Senate. There were companion bills. And even under a democratically controlled Senate with a Democratic president that was more interested in sustainability and right to repair, those bills didn't go anywhere in the last Congress either. So the notion that there will be any sort of federal right to repair legislation anytime soon in the US is highly doubtful, which is why it's more important, as Michelle and Samantha and we've all been saying, to follow the states. Because if the states are interested in enacting right to repair, they can do so, and they can do so on their own terms, and the states don't have to line up with each other. So that's why, even like Orla was just saying, we monitor every state every day. We have a team of people that does this so that we can stay on top of these changes in the states. Because, in the absence of any sort of federal requirements in the US, you really do have to pay attention to all 50 states.
Absolutely. Thanks, Kelly. And do the proposals address any kind of penalties for manufacturers who don't comply with these laws?
I can take that one. So I can discuss a little bit about the US proposed bills. So the penalties vary depending on the bill. The bills discussed and presented throughout the presentation take different approaches, but I can name some examples. For example, the Texas HB 2963 does not establish specific penalties or fines, but it simply gives a reinforcement to the state attorney general, who can act if a manufacturer fails to comply after receiving a 30-day notice. And in contrast, we have the Washington SB 5423, which includes a stronger language, and it treats violations as unfair or deceptive practices under the Consumer Protection Act, and also references identity crimes under state law. So it varies, but it depends directly on the specific bill, but we have different examples depending on the bill.
Thank you very much for that. Have any of the EU member states implemented the EU Right to Repair Directive yet?
Okay, I think that's once for me, the EU. So, okay, so not as yet is the short answer. The member states have until July 2026 to transpose this into their national laws. Now, the directive does say that the member states can enact stricter legislation. So it's really important that we do look at the member state level, because it's a directive and there can be differences in all the member states. And the other thing is that, similarly to what Samantha was mentioning for the US, there isn't any actual penalties listed in the Right to Repair Directive, and this is going to be set at member state level. It's up to the member states to do this. So it's going to be important when we do see these laws, which have to be enacted by July next year, that we do look at the penalties that are going to apply in each member state. So we're watching it closely. Thanks.
Thanks, Michelle. And last question now, I'm just keeping an eye on the time. If the legislations were approved, what would this mean for products that have already been sold?
So I can take that one. In most cases, the bills focus on future compliance. So generally, products that have already been sold wouldn't be covered unless the specific proposal or the law includes a specific retroactive clause. So we have a clear example of one of the proposed bills that I mentioned. It was the Washington SB 5423. So according to the bill, the text of the bill, if enacted, it would require manufacturers to provide part, tools, and repair documentation on to sold or used products in the state on or after July 1st, 2021.
Great. Thank you so much, Samantha, and also you, Kelly and Michelle, for the amazing session and answering all those questions. There's been plenty more But as I mentioned, we'll reach out to you directly with those answers if we didn't cover your question during that session. Thank you all so much for tuning in with us today, and we really hope you found it helpful and look forward to seeing you in our upcoming webinars. You can check out our resources section on the website to stay updated and to access our latest white papers, blogs, guides, and of course webinars, both future and on demand. And we have plenty of upcoming content, so make sure you do keep an eye out. Our next webinar, our hugely popular series, Chemicals Quarterly Q1 2025 Regulatory Update, is scheduled for April 23rd, led by Cassie Persian and Kim Plash from Compliance and Risks. So we really hope to see you there. Thank you very much. Have a great day.